Hi, I'm Rebecca Fruchtman, and so pleased that you can join us today for this 8th webinar in the Mayer Brown Global Supply Chain Finance series. As many of you already know, we have a dedicated receivables and supply chain finance team around the globe to serve our clients' needs. Many of you may have been listening in on our webinar series. We certainly hope we can see each other next year in person in lieu of remote sessions. If you missed any of the previous webinars, there's a link to our Mayer Brown website at the end of the slides where you can listen to any of our webinars. Again, we can support any of the challenges you may face anywhere along the supply chain. So today we're discussing the UN Convention on the Assignment of Receivables in International Trade. We at Mayer Brown are excited and honored to have with us the individuals who really were the driving force behind the U.S. ratification of the convention that happened just a little over a year ago on October 15, 2019. Let me introduce our esteemed panel. From our firm, we have Alex Dell, who heads the banking and finance group of our London office and co-chairs the firm's asset-based lending practice. Let me next introduce Hal Burman, formerly of the Office of Legal Advisor of the United States State Department, and next, Jae-Sung Lee, who is a legal officer at the International Trade Law Division of the UN Office of Legal Affairs based in Vienna. We have Bob Trojan, who is a senior advisor of Nat Law and founder of Token Insights and Financial Services Insights, which is his advisory firm that specializes in global strategy, fintech, regtech, and regulatory legislative affairs. And lastly, myself. I am a banking and finance attorney in the Chicago office of Mayer Brown. My practice focuses on global supply chain finance and other types of receivables financing transactions, both domestic and cross-border, as well as letters of credit. What is the UN Convention on the Assignment of Receivables in International Trade, and why is this convention so important? So the UN Convention is a treaty that, if adopted by a number of countries, will remove substantial legal barriers to cross-border receivables financing and sales transactions. What are its key features? It validates assignments of receivables in bulk, such that the convention does not require that each receivable be identified individually. The convention permits, as a matter of contract between the assignor and the assignee, that future receivables can be assigned. And note that assignments, the term assignments under the convention, applies both to extensions of credit secured by receivables, such as in asset-based lending, and also a true sale of the receivable. The convention generally invalidates contractual limitations on the assignment of receivables, and this is in line with UCC Section 9-406, with which many of you are familiar. The convention enhances certainty as to the effectiveness of a sale or assignment between the assignor and assignee, and as against the account debtor or the obligor. It clarifies the law that's applicable to priority of competing claims in a seller bankruptcy, such that the law of the residence of the seller will apply. Please note also that a receivable under the convention is any contractual right to payment, and it can arise and be generated from a much broader range of assets than under traditional law. For example, a receivable can arise from real estate and also in the consumer purview, including certain credit card receipts. Giving some context and stepping back and looking at the global macroeconomic setting here. Some statistics from the Asia Development Bank and other sources show that at least pre-COVID, global merchandise trade was at U.S. $18 to $20 trillion per year. The service sector trade, provision of services cross-border, represented an additional $5 trillion in economic activity and value creation. 80% of cross-border flow of goods, and increasingly the cross-border service sector, actively relies on some form of trade financing, according to the World Trade Organization. So what this shows is that there is a persistent unmet demand for trade finance of about $1.5 trillion annually. These statistics demonstrate vast untapped opportunities for medium and smaller companies, or as the acronym is used, SMEs, around the globe to gain access to financing, and for financial institutions and fintechs to provide that financing. This is the access to credit gap that the convention seeks to address. Trade activity is financed using a range of techniques, and those of you on the webinar are already familiar with these, and they are part of your day-to-day work life. Supply chain finance, factoring, asset-based financing, trade finance securitizations, and letters of credit. The convention is applicable to all of these various types of financings. So I'd now like to turn the microphone over to Hal Burman to provide a brief history and further background on the convention.
Yeah, this is Hal Burman, and I have a very brief history, which I think will illustrate the fact that although it's been a long time since the treaty was negotiated, that has not been for lack of support in the treaty. It began in the mid-1990s when a number of commercial sectors, both in this country, in the U.S. and the UK and elsewhere, came together and wanted to draw on the economics of Uniform Commercial Code Article 9, which had long tested certain very modern approaches to secured financing. At that point, 3 negotiations were begun almost simultaneously. One at Untitled, which the UN Convention on International Trade Law, which produced the convention that we have in front of us. Secondly, at Unidroit, another international body in Rome, which began a parallel convention also drawing on UCC Article 9, but dealing with asset-based finance. And a third at the Organization of American States, which produced an OAS model law, but written like a civil law treaty as opposed to a common law type drafting. All 3 came out with the same kinds of results. All 3 are compatible with each other. The game changers, you've heard Rebecca already discuss these. It certainly expands very considerably the kinds of transactions that can produce receivables that become good collateral and can be assigned. It would very considerably increase the number and types of commercial entities, including small, medium, even micro businesses that can access the supply chain financing or other kinds of financing. Negotiation of a convention like this with experts in the room at the UN, and economists and so forth, that is one thing that takes a fair amount of time, but getting treaties then ratified like this one, which would be quite a radical change in many countries who do not have modern secured finance laws, that takes years. That's a long track. The World Bank has been involved, IFC, regional development banks, even the IMF at one point. When it was finally negotiated, some in the U.S. and elsewhere outside of the country thought the economics were so strong it would sell itself. Back in the U.S., people said, okay, we're not going to ratify the treaty because it may have complicated language and legal opinion issues with the law that we already have on the books. And we don't need to actually ratify the treaty to get that law. That turned out to be, I think, a predictable error in how things happen internationally. Once the U.S. backed off ratifying, and the UK did also, but for completely different reasons, a number of other countries just pulled back. And they said they're not going to go forward with the treaty because its principal supporters have not moved to ratify. Once that problem was understood, the U.S. did go up. We went up to the Senate of the U.S. to move for ratification. That was in the year 2007. Some of you, all of you, I'm sure, will remember 2007, 2008, 9, 10, and the financial sector problems that were very much on everybody's front table. There was no way at that time to get people politically to take on a new treaty, certainly in this country, on financial law. It had to be taken out of the Senate at that point, and then it sat for a while until Bob Trojan, who's also going to be on this call, and others assembled a very strong coalition of associations involving trade finance. The Chamber of Commerce, BAFT, BAFT, Commercial Finance Association, so forth. And that moved it through the Senate. That's and on to ratification. You will find when you finally access once it comes into force, the documents you will at the UN, which is the depository, you will see that the U.S. entered a number of declarations and understandings, all of which were intended to make sure the treaty would work seamlessly with the Uniform Commercial Code and problems would not arise by having two texts involved. Thank you. Now I'm going to turn it over to Rebecca, who is going to go into problems that one has to pay attention to.
So what are the current problems the Convention seeks to address? Well, local law requirements can be very elaborate and complex for receivables, financing, and sale. It's really a patchwork across the globe of different requirements. Sometimes in certain jurisdictions, notary publics have to be involved, or it's recommended that they be involved. For example, in Spain, if the supplier is Spanish, it is recommended that each batch of receivables, if it's an ongoing sale, be recorded or endorsed before a notary public. Other formal government processes can come into play, like having to register a document with a court. I worked on a transaction in Honduras where it was the case that had to be done. The transaction document had to be registered with a court. There are other types of requirements regarding apostilles for parties that are outside of the jurisdiction having to be obtained. Also, receivables must be described in granular detail. So again, in Spain, there's a requirement there be various specific data regarding each receivable being provided. Notice to the account debtor has to be given in a particular way at a particular time, and in some jurisdictions, the notice has to be given in the language where the account debtor resides, and no other language. Receivables, and this is a really big one, and is endemic in many jurisdictions around the world. receivables can't be sold if there's an anti-assignment clause in the underlying sale contract. That's it. Receivables can't be sold on a batch, future, or undivided basis, meaning that at the outset of a contract to sell receivables, there can't be a forward-looking agreement to sell any receivables arising in future. And then laws that apply to the priority of claims in bankruptcy are uncertain. They vary from jurisdiction to jurisdiction or even by court, from court to court. It's very difficult to navigate the conflicts of law issues in a cross-border receivables financing, given that you have the financing party and you have the obligor on one hand and you have the seller supplier on the other. So all of these problems make a financing party, such as a financial institution, very nervous, very skittish about getting involved, investing the time and money to hire legal counsel and navigate the landscape in a particular jurisdiction to affect the receivables financing. Small and medium-sized businesses throughout Latin America, certain post-Soviet republics, the Middle East, and Africa don't currently have access to this type of financing, which is another major problem, which is more of a macro problem that the convention seeks to remedy. Oftentimes, credit in these jurisdictions is tied up in illegal assets such as real estate, and there is a socioeconomic implication to this, where the credit is only available to a certain tier or privileged tier of society within certain jurisdictions because they are, they own vast land holdings or corporate interests. So the knock-on social implication of that is that the SMEs with fewer resources don't have access to capital. Alex, you've had tremendous experience with cross-border financings in Europe and elsewhere. What are some of the problems you've encountered?
Yes, many thanks, Rebecca, and I think you make some really, really important points, and maybe just to delve a little bit deeper into some of them, if I may. To give just a little bit of background, for over 25 years now, I've been advising on the legal issues arising from the range of working capital products that you described earlier. Ensuring that the sale or assignment of accounts receivable is legally effective has been a core component of my working life as a working capital finance lawyer. I've witnessed over the years an increase in the size and scope of some of these receivables financing facilities and programs in market, to the point where a structure in excess of $1 billion across maybe 20 or more jurisdictions is no longer considered remarkable. And the reasons for this are diverse, but I suspect that financial institutions are better now at finding solutions for clients through a combination of skills within their organization, coupled with consolidation in certain sectors, increasingly sophisticated margin arbitrage, and a focus on specific accounting treatment outcomes. But core to these receivables financing structures is a need to properly understand a complex and uneven matrix of legal issues, which invariably differ from jurisdiction to jurisdiction. And it is this that the Convention is looking to address, in my view. And I'll give you some illustrative examples. You'd be blamed for thinking that the US and England, New York law and English law, being the typical choice of law for international trade transactions, think about legal true sale issues in substantially the same way. But you'd be wrong. In England, we focus on whether the construct has the characteristics of a sale or the characteristics of a security interest. In the US, the analysis is focused on the presence or otherwise of credit recourse, together with a focus on bankruptcy isolation. Secondly, You touched on anti-assignment language, and for a lot of jurisdictions, anti-assignment language is effective to prevent the valid transfer of a receivable. Jurisdictions such as England, Italy, the Nordic countries, the Benelux countries, Hong Kong, Singapore, Australia, New Zealand, and so on. But that isn't the case in the US, it isn't the case in Germany, and until recently France, although the position there has changed and is now unclear. The protection afforded to purchasers of receivables varies from jurisdiction to jurisdiction. The US has the UCC, a model which is broadly adopted by Canada, Australia, and New Zealand, with their respective versions of a Personal Property Security Act. But in most countries, a uniform property register does not exist for purchasers of receivables, and so the protection afforded to them arises from the act of notifying the account debtor that there's been an assignment. Even then, the legal effect of notice differs from jurisdiction to jurisdiction. In some, such as Italy, Sweden, Denmark, Finland, notice is required to have a valid assignment at all. In others, notice regulates the position as between competing interests in the same receivable. In others, again, it regulates the position with regard to third parties, which may or may not include insolvency practitioners, depending on where you are. So hopefully you're getting the picture. My working life as a receivables financing lawyer often feels like I'm playing 3D chess with a patchwork of different laws, which have the unfortunate habit of evolving just as you get your head round them. The convention is seeking to create harmony where there is currently endless variation. Variation as to whether you're even authorized or regulated to purchase receivables. Variation as to how you transfer title to receivables. Variation as to whether anti-assignment language is effective. Variation as to how you perfect an assignment. Could be by notarization, as you said, Rebecca, or by notice, as in many other jurisdictions. Variation as to whether you can assign present and future receivables or just present receivables. Variation as to the sufficiency of data required as to what is actually being assigned, such as in Germany, or the precise date of the assignment, which is the data certa principle in Italy. Variation as to whether a third party claiming an interest in the same receivable is able to prime the purchaser of that receivable. Variation as to the impact of a seller's bankruptcy or insolvency process on the purchaser of a receivable. This is at the heart of the matter. Is the receivable an asset of the seller on its bankruptcy, or is the legal effect of the sale such that the receivable is validly owned by its purchaser and cannot be clawed back by the seller's insolvency administrator? And the answer to that question depends on the extent to which there has been accurate compliance with the issues I've just described in the laws of all the relevant jurisdictions to the transaction, which we know differ in substantive and subtle ways. This UN convention is bold and ambitious because it's seeking to solve some highly complex legal issues by inviting countries to look at their laws on proprietary title transfer and true sale, trusts, priority and perfection, and of course bankruptcy and insolvency laws, which in some cases are based on centuries of case law precedent, statutory framework, and customary practice. If the convention becomes widely and evenly adopted by jurisdictions, a couple of things will happen. Firstly, my working life and that of my team at Mayer Brown should become much more straightforward as we can stop playing 3D chess. Secondly, and far more importantly, the universe of financial institutions which are willing to get involved in the financing of trade receivables on a cross-border basis, the complexity of which can be a disincentive, should materially increase. And if that happens, then there is a good chance that the world's unmet demand for trade financing can start to be properly addressed. I'll pause at that point and hand it back to Bob.
Thank you, Alex. So what are the convention's objectives? So why did we go through this enormous effort to create a a global international convention. This took many, many years of effort of dozens of people at the United Nations and various governments, and ultimately needed to be approved by the UNCTAD Commission itself and the UN General Assembly. Why did we spend years of effort trying to do this? I think the preamble does a good job of expressing that, to promote the availability of capital and credit at more affordable rates. And so what that means is credit is expensive, capital is expensive. And once you get into the realm, as Alex mentioned, of cross-border transactions, those are very complex and can be very uncertain. And so the preamble continues to create certainty, transparency, and modernization. And so modernization is one of the key points, even though this was done some years ago. It was really many years ahead of its time. And so now we have a state-of-the-art modern regime to be able to look at cross-border transactions. And the most important part of that last sentence is to create certainty. Not perfect certainty, but more certainty, particularly for lenders in cross-border receivables transactions, so that they will provide more capital, more credits to SMEs, to corporates, and to decrease the friction in cross-border trade. And now I'd like to turn it over to Jay to continue those comments.
Thank you, Bob. As Hal and others have hinted, the convention itself was prepared by the United Nations Commission on International Trade Law, an intergovernmental body established in 1966 by the United Nations General Assembly for the harmonization and modernization of international trade or commercial law. Better known for its acronym UNCTAD, it has promulgated a number of conventions, model laws, rules, and guidance texts in a wide range of areas. Now, in response to the divergence of laws, as mentioned by Alex, in 1995, the Commission decided to prepare a uniform law on assignment of receivables financing, and the convention was the result of 6 years of negotiations in the working group and at the Commission. Now, as Bob hinted and mentioned, let me just emphasize that the main objective of the Commission is to increase access to credit at more affordable rates across national borders. This facilitates more cross-border trade, and that is the main objective of the Commission. The Commission achieves this objective by reducing legal uncertainty, as also mentioned by Bob, and thus addresses a number of issues arising in the context of receivables financing transactions, as Alex and Rebecca had also hinted. So in summary, the Commission establishes principles and adopts rules relating to the assignment of receivables, enhancing legal certainty, and possibly formulating and functioning as a uniform law that would be applicable globally, thus achieving harmonization or harmony, as Alex put it. So now I put it back to Rebecca to discuss some of the key provisions of the convention. Rebecca?
Let's dive into some of the key features of the convention. With respect to its scope, the convention only applies if the assignor and assignee are located in different countries from one another, or the assignor, which is the seller, or the account debtor on the receivable are located in different countries. So this is the threshold eligibility requirement for application of the convention. Assignments can be in bulk, future receivables can be assigned, and general descriptions of receivables are okay. The convention overrides local laws that would otherwise prohibit bulk assignments of receivables, present transfer of future receivables, or undivided or partial transfers of receivables. By permitting assignments of receivables in bulk, the convention eliminates the requirement that each receivable be identified individually, as is currently mandated in many countries. general descriptions of receivables being assigned are effective so long as the receivables are described in a way to be identifiable to the contract of assignment. Likewise, future receivables could be assigned by a one-time current assignment between the parties, so long as they can be identified as the receivables to which such assignment relates. Next, and very importantly, as we've all been alluding to, the convention generally invalidates contractual restrictions in the underlying sale contract along the lines of the Uniform Commercial Code. So this means that if the buyer in the underlying sales contract has insisted on an anti-assignment clause that says that the contract cannot be assigned, in most jurisdictions currently, that anti-assignment clause is going to be upheld outside of the United States. So if the convention is ratified and adopted evenly and broadly, these anti-assignment clauses are going to become ineffective, unenforceable, null and void. And what's really exciting about the convention is it provides that any country which adopts the convention cannot decide to reserve or ignore or modify the anti-assignment provision in the convention. So in other words, if a country ratifies the convention, they have to accept the override of any anti-assignment clauses along the lines of the UCC without variance or without any negation. So I think that's very, very powerful, very exciting. Either or both the assignor or assignee can send the account debtor notice of assignment or a payment instruction under the convention provisions. And this means that after the account debtor receives notification, its debt is discharged only by paying the assignee. And of course, the assignee will be the financing party, the financial institution or fintech who's providing the financing. The convention further provides that notification of the assignment requires a writing that reasonably identifies the assigned receivables and the assignee, and that notice will be effective when received by the debtor if it is in a language that is reasonably expected to inform the debtor about its contents. So that's a little bit more flexible than some of the language requirements in certain jurisdictions. These provisions regarding notice are significant because the convention, in contrast to prevailing law in many jurisdictions, places no restriction on the timing or the manner in which the notice must be sent. Very important. In fact, the convention allows for notification of the assignment to relate to the receivables arising after the notification. So even in England currently, and in so many other jurisdictions, the timing of the notice is critical in that it has to go out concurrently with the sale of the receivable and not before. So this flexibility on timing is important. The convention is also silent on the oftentimes onerous requirement in many jurisdictions that the receipt of notice be confirmed each time in writing by the account debtor or by a return receipt of some kind. In many jurisdictions, if the account debtor does not receive notice of the assignment at the right time or in the right way, or if there's no solid evidence confirming the account debtor's receipt, the assignment may be unenforceable against the account debtor. Through silence, the convention appears to eliminate any kind of local law notification confirmation requirement, although this is not entirely clear. But I would say that the convention facilitates the most popular and low-cost way to provide notice, at least in supply chain payables financing programs, where there are, where there are ongoing sales of receivables to the financing party over time. It's the use of platforms, electronic platforms, to generate and send electronic notices to the debtor. Those work very, very well under the convention. One of the most important parts of the convention addresses the priority of an assignee's interest in a receivable as against competing claimants, and Alex has spoken about this in some detail as a concern, as a problem the convention seeks to address. So the convention looks at competing claimants, such as other creditors of the seller, assignor, competing assignees, or the supplier's trustee or administrator in bankruptcy. The convention provides that the priority of an assignee's interest, again, that's the seller, is determined by the law of the jurisdiction where the assignor is located. That law also determines whether the assignment is a true sale or secured financing. If a challenge is made to the priority outside of that jurisdiction, the court must nonetheless apply the laws of the jurisdiction where the supplier is located, unless those laws, or seller, is located, unless those laws are contrary to public policy. This is a huge selling point for the convention because conflicts of laws in the event of a supplier's bankruptcy and a cross-border financing can be a real morass with no real certainty as to which law a court might choose. Not part of the convention itself, but an annex to it are model priority rules, including a set of rules based on registration of assignments. The annex raises the possibility of a global searchable and filing registry along the lines of the UCC Secretary of State registration system or other similar registration systems, the PPSA in Canada, Australia, and other jurisdictions. Parties can search, and if a party registers, it would constitute a binding proof of assignment. This would be a voluntary system. At this point, it's probably years away, but it's interesting that there is this annex to the convention that sets forth this potential registration system. So I'm going to now turn the floor over to Hal to discuss enforcement of the convention if there is a violation by an adopting country.
Okay, what happens when things go wrong? A country fails to deliver remedies, failed to provide a process that's effective. Where do the parties go? Like other commercial law treaties, there's no provision in the treaty for any particular kind of dispute settlement. So remedies are available to parties as they might be under applicable law under any other commercial case, except that there is the potential for an action against a government for failing to provide a remedy that it has agreed to make available by virtue of ratifying this treaty, although that might be a somewhat difficult route certainly in many countries. The underlying laws, one of the reasons why this is important, the underlying laws of many countries that may ratify the convention may be quite inconsistent with the modern financing provisions in the convention. So there is that room for remedies to be quite difficult to actually access. Court procedures often involve a lot of difficulty assessing, certainly in these multilateral commercial transaction scenarios, where the applicable law lies. In this case, if a country adopts a particular declaration in the convention, it will adopt uniform rules along with other countries on applicable law. That is designed specifically to narrow the number of times that becomes the effective major issue in a litigation or an arbitration. But all that takes time and may not be the best route to go. The experience that we've had so far in conventions like this, such as the Cape Town Convention, which also employs receivables as an important part of its financial provisions, is that the first responders can be perhaps most effectively the international credit community itself. The experience that we've had is that when, however that's done, the international credit community goes to the government involved and explains that if remedies cannot be reasonably available as provided under the convention, then the spigot is either going to be seriously tightened, rates go up, credit is restricted again to the extent that it might have been available with the convention in place, or the spigot will be turned off. And that message, in some cases, was repeated by our department through diplomatic channels to alert ministries in a particular country that having credit visibly tightened up or turned off cannot easily be reversed quickly. And that, in fact, seemed to have provided the impetus for those countries to get with the changes that the convention foresaw and actually make the appropriate remedies work and make them available. So that's something that the credit community itself can help bring about. And I would anticipate the organization of a kind of a working group, so there's a lot of coordination between the financial community and others in trying to bring this convention not only in force in other countries, but to make sure it works in other countries. I would anticipate that may be one avenue to helping the credit community itself organize to provide this first responder and perhaps most effective means of straightening out problems in other countries that adopt the convention. Thanks. And now I'm going to turn it back over to Rebecca.
So, what are the next steps here? The U.S. has now ratified the convention. Liberia has ratified the convention. Jay, can you give us some details on steps going forward for the convention?
Thanks, Rebecca. The ratification by the United States in 2019 made it the second state party to the convention, following Liberia, as you had mentioned, which succeeded to the convention in 2005. And as Hal noted, the ratification of the United States was a big push for us and provided us an opportunity to reach out to other governments. And yes, there is growing interest among certain other governments. We have two other states, Luxembourg and Madagascar, that have signed the convention, but they have yet to ratify. Now, according to Article 45 of the convention enters into force after 5 ratifications or accessions. And the efforts by the UNCITRAL Secretariat is to ensure that the convention enters into force in the next 2 to 3 years, meaning we need 3 more states to become state parties. Now, as Hal noted in his presentation with regard to the ratification of the convention by the United States, the convention allows states to make declarations with regard to certain articles when depositing their instrument of accession. Now, unlike reservations, which exclude or modify the legal effect of a treaty, and which is not allowed under the Receivables Conventions, declarations aims to clarify the state's position as to their understanding of the manner or how a provision is to be interpreted. Now, this provides flexibility to states when considering to become a party to the convention, particularly if one of the provisions could be seen to conflict with the domestic laws. So if you are aware of any other governments that are interested in becoming a party to the Receivables Convention, please refer them to myself at the UNCTAD Secretariat, and we will be happy to provide any assistance that is required. Over to you, Bob.
Thanks, Jay. And as you can see here, the U.S. coalition, which I led to promote the ratification of the Receivables Convention, was large and broad. And the names you see here, the International Chamber of Commerce, their U.S. chapter, BAFT, the U.S. Chamber of Commerce, NatLaw, as well as nearly a dozen other industry groups actively supported the ratification. And this took significant effort. This was a tall order. It took us over 3 years to get through this process. So we needed to get the President of the United States to send it officially to the United States Senate for their advice and consent. The Senate then needed to go through their committee process, the Senate Foreign Relations Committee, the Senate Foreign Banking, or the Senate Banking Committee, to give that advice and consent. And then the executive branch, a different president, needed to deposit the instrument with the United Nations. And so that was a tall order. And to give you some perspective, this is the first United Nations convention ratified by the United States in 31 years. And so the way we were able to do that, and we think is a map for the way forward, is we made this a very technical and apolitical discussion, so that there were no political points that could be made by ratification. This is a good idea supported by industry that will help get credit to businesses. And that was a persuasive argument, but one that took a long time to do in the United States. And so our position is to continue that messaging going forward because it was effective, even though it took nearly 4 years in the United States. So back to you, Rebecca.
Bob and Jay, can you give us some background on what is being done in coordination with the World Bank to raise awareness and promote global ratification and adoption of the convention? Also, we'd like to hear about other countries that have already undergone secured transaction reform and the importance and relevance of the Cape Town Convention. We'll then hand the microphone over to Alex to describe for us some of the major challenges he sees to the convention's widespread and consistent adoption. So, Bob, over to you.
Thanks, Rebecca. And as Jay mentioned earlier, we're looking to really take the significant momentum that we got from the U.S. ratifying of this convention to continue that process and get to the magic number of 5 countries and then beyond. And so the countries we're working with and in communications with through the World Bank and directly with the countries are those who have already done secure transaction reform or are in the process of doing secure transaction reform, as well as those countries who have ratified the Cape Town Convention. As Hal mentioned earlier, the Cape Town Convention and the Receivables Convention were simultaneously negotiated. And so the countries who have an appetite for reform and the legal concepts around the Cape Town Convention should be open to the concepts involved in the Receivables Convention. And so there is no reason we can see that the Receivables Convention can't blossom into as many countries, 70+ countries, like the Cape Town Convention. Over to you, Jay.
Thank you, Bob. As I noted, the UNCITRAL Secretariat continues to promote the convention continuously in all possible opportunities. Now, after the convention, UNCITRAL has formulated a number of texts on secure transactions, most importantly, the Model Law on Secure Transactions, which covers security rights in all types of movable assets, including receivables. The Model Law also covers outright transfer of receivables. Now, there's growing interest by governments all over the world to increase access to credit for small and medium-sized enterprises. And one of the first steps that they take or consider is secure transactions reforms, providing legislation that would make it possible for businesses to obtain credit using collateral that they have, like equipment, inventory, intellectual property, and other types of movable assets. As the UNCITRAL Secretariat is involved in such reform efforts, often in coordination with the World Bank and other development banks like the Asian Development Bank and the EBRD, we try to sell the Receivable Convention, particularly when the use of receivables is prevalent in that economy. In essence, we try to piggyback on the momentum of the Secure Transactions reform because it's often difficult to engage with government authorities who are not so interested in or who do not have knowledge about receivables financing. For example, because it is a United Nations convention, some officials think that it is to be handled by the diplomats in the Ministry of Foreign Affairs or the State Department. But from a diplomat's perspective, the content of the convention is quite technical and tell us that it is under the auspices of the Finance or the Trade Ministry. And this is why we appreciate efforts to raise awareness about the convention and to explain the benefits that the convention can bring, which helps us to persuade government officials. A difficult question that we often face when we reach out to states is whether a comprehensive secure transactions reform should come first or the accession of the convention should be considered first. Ideally, they should be done concurrently, but this really depends on the interest of the respective state, the motive behind their reforms. For example, if the promotion of the factoring sector with a large international component is their key initiative, we would suggest that they look into the convention first. If the objective is more general, for example, to increase access to credit for MSMEs, a comprehensive reform based on the Model Law is what we suggest that they do. Either way, there is need for coordination, and the Secretariat stands ready to lend any support to those governments. Thank you. Over to Alex.
Thank you, Jay. So it's fallen to me to touch upon the challenges or impediments to adoption. As we've heard, the Convention allows for declarations. This means that a country could ratify the Convention but retain laws that would not recognize certain aspects of the Convention. Although the Convention contains a general prohibition on changing or invalidating the legal effect of its provisions, the challenge is going to be to persuade governmental decision-making bodies to join the Convention in totality without any or minimal deviation. Otherwise, the result may be a patchwork of inconsistent and potentially conflicting approaches to interpretation and implementation of the Convention principles and provisions, and a patchwork inevitably falls short of the stated objective, which is harmonization and uniformity. Even if industry groups fully understand the importance of the Convention, each country ultimately becoming a party to the Convention would need to involve its Ministry of Foreign Affairs and other relevant officials who may not necessarily be receptive to the benefits. Countries which, for example, are undergoing a more comprehensive reform of their secured transaction laws may prefer to wait until they have completed those reforms. It may also depend on governmental or parliamentary bandwidth. We're in the midst of a global pandemic, of course, the effect of which will, I suspect, last for years. Brexit is consuming the thoughts of 28 major trading nations, again, the impact of which will continue in the short to medium term. And the US-China trade wars may prove to be somewhat of a distraction to the objective of harmonizing global assignment laws. On the subject of the EU, it will be interesting to see how it approaches the Convention. given that it has already gone down this path as between the then 28 member states, with Rome I, a 2008 regulation which seeks to harmonize laws applicable to contractual obligations. We don't have time today to discuss Rome I in any detail, but that harmonization process, although broadly positive, did experience its own challenges with the uneven interpretation at local law level. Many countries, and certainly it's true of the UK, typically conduct a consultation process in relation to new legislative proposals, with interested constituencies and professional advisors invited to contribute. Now, these can become protracted, particularly if there are material complexities or issues which involve amendments to long-established legal principles. I suspect that for countries with comparatively underdeveloped laws concerning the assignment of receivables, and to Rebecca's citation earlier in this presentation, Middle East and Africa come to mind, the Convention may be more readily welcomed than perhaps jurisdictions with a centuries-old framework of laws which broadly are understood and work. It may also be that the countries which have a UCC equivalent or are planning to have one may more readily embrace the Convention's principal construct than those that do not. Ultimately, I think that the toughest challenge to the Convention's widespread and consistent adoption will be overcoming the underlying disparities in local laws of title transfer, bankruptcy, and insolvency that I highlighted a bit earlier. That said, with my wonderful panel colleagues at the wheel and with the heft of the US behind this, I think anything is possible. Back to you, Rebecca.
Hal, Bob, and Jay, please tell us, going forward, what in your mind will be the most effective ways to promote the Convention, and what aspects of what you or your organizations have already done or plan to do get you the most excited about the prospects for widespread and consistent adoption? So Hal, please take the microphone.
Okay, the first thing that I think needs to be done and would be effective is to organize a group, informally at first, a working group that would be people engaged in this process in a variety of countries, hopefully, to coordinate, to assist in getting contacts moving in various countries, and to mobilize active players in financial and other sectors in each of the countries involved in this working group to use their efforts to build the contact system and to move ratifications forward. In addition to which, this group, which was very effectively done by the model under the Cape Town Convention, which did precisely this, could develop important guidance for countries to take into account as they move forward with ratification and also to effectively implement the Convention. And over to you, Bob.
Thanks, Hal. So I would concur and also add that we've seen significant interest by not only individual states as well as the international community, but also from trade associations around the world focusing on the secured transactions, so factoring associations and banking associations, and really getting the industry players plugged in and even more excited about this, I think will be extremely effective. In terms of getting us to the magic number of 5, I think some of the leading candidates are the immediate neighbors of the United States, Canada and Mexico, as these 3 countries tend to move in tandem legally, and then look at other countries who have done secure transaction reform as probable next steps. Over to you, Jay.
Thank you. I think I can only concur with Hal and Bob. And as a member of the UNCITRAL Secretariat, we'll continue to monitor and update the status of the convention, as well as any ongoing secure transactions reform efforts. Now, in addition to the promotion of the convention, we also take part in coordination with other agencies, and we are taking part in efforts to provide additional guidance to states. And in this regard, I would like to just mention work that is underway in a sister organization of UNCITRAL, the International Institute for the Unification of Private Law, UNIDRAW, to prepare a model law on factoring. Now, the model law on factoring, which is being prepared to be entirely consistent with the Receivables Convention, will help states when they enact domestic legislations implementing the convention. And we hope that the model law will be prepared quite soon, which would be another push for the adoption of the convention by other states. Thank you, and back to you, Rebecca.
We've talked about why the convention is important, its key features, the problems it tries to address, the challenges to widespread and consistent adoption, and those initiatives the panel believes will be the most effective in positioning the convention for global success. If you want more information on the convention, together with a summary of some of the issues we've covered today, we would encourage you to read a copy of the Mayor Brown Legal Update on the Convention, which I co-authored with Alexander Malakat, whom many of you know, at the link provided here on slide 17. So that's the Mayor Brown Legal Update on the Convention here at slide 17. Also, if you or your organization would like to get involved and help raise awareness, you should feel free to reach out to any of us on this panel. All of our contact details are provided in this deck. Many thanks for joining us.